$12.50. That was the number sitting on my desk that November morning. Not thousands, not hundreds, $12.50. In 32 years on this bench, I have seen fraud, I have seen violence, I have seen the full and terrible weight of what human beings are capable of doing to one another. But I will tell you something I have learned that they don't teach in any law school. Something that took me 3 decades to understand completely. The smallest numbers sometimes hold the largest cruelties. She walked into my courtroom in a coat that was too big for her. Green, or what used to be green. Hands that had been washed and worked and washed again until the skin had simply stopped recovering. She was holding a plastic folder, the kind you find in a dollar store. And inside it were receipts. Organized receipts, because she still believed, after everything they had put her through, that this place ran on evidence. She had been to that school 4 times. 4 times with money in her hand, asking someone to take it. 4 times a door had been closed in her face by a man in a gray suit who looked through her like she was a problem in a spreadsheet rather than a mother running out of time. Because her son had 3 days left. 3 days before something closed forever. Something he had worked for, written for, fought for in the quiet way that kids fight for things when nobody is watching, and everything depends on getting it right. I looked at her. I looked at the man who had filed a formal legal complaint against her for the crime of not giving up. And I knew, before a single word of testimony had been spoken, that there was something in this case that went far deeper than $12.50. Something that man in the gray suit had no idea I already knew. But when I asked her the one question that changed everything in that courtroom, what happened next I have never forgotten. Before we begin, drop a comment and tell me where you're watching from and what time it is where you are. If stories about justice, empathy, and hidden truths move you, make sure you subscribe to the channel. We tell the ones that stay with you. There are mornings in this courthouse when the silence feels earned. Not the silence of an empty room, I mean the silence of a room that is waiting. The bailiff standing by the door with his coffee going cold in his hand. The court reporter with her fingers hovering over the keys, not typing yet, just ready. The smell of old paper and older decisions hanging in the air like something that never quite leaves, no matter how many times you open the windows. November had come in mean that year. The kind of cold that doesn't announce itself. It just settles in, gets comfortable, and refuses to leave. The heating in courtroom 4 worked the way a lot of things in that building worked. Partially, inconsistently, and only when it felt like it. I had been wearing my robe since 7 in the morning and I was still cold. I remember looking at my docket that morning and feeling something I had learned over 32 years to pay attention to. Not dread exactly, not curiosity either. Something closer to recognition. The way you recognize a type of storm by the color of the sky before it arrives. The case number was unremarkable. The charge summary was 2 lines long. The amount of money at the center of it all was $12.50. I had seen men walk into this courtroom who had stolen thousands. I had seen women who had done things that kept me awake at night, not from anger, but from sorrow. I had seen the full and terrible range of what human beings do to each other when they are desperate, or afraid, or simply cruel. And I had learned the hard way, through years of getting it wrong before I started getting it right, that the size of a number tells you almost nothing about the size of a wound. $12.50. I set the file down and looked at the clock on the wall. The second hand moved with that particular slowness it always had, the way time moves in a courthouse, like it knows it has nowhere to be and is in no hurry to get there. 7 minutes before 9. I picked up my coffee. It was already cold. I heard her before I saw her. Not her voice. She wasn't speaking. I heard the sound of the door at the back of the courtroom opening, and then the specific rhythm of someone walking who is trying very hard not to look like they are afraid. There is a walk I have seen 1,000 times in this room. It is the walk of someone who has never been in a courtroom before. who has watched enough television to know that they are supposed to look calm, and who does not feel calm at all. Short steps, shoulders slightly raised, eyes moving just a little too quickly, cataloging exits and faces, and the distance between themselves and the door they just came through. She was wearing a green coat. The color it used to be, I couldn't say. It had been washed so many times it had become its own shade of something. A tired green. The green of a plant that was doing its best. It was too big for her. Either she had bought it that way, which I doubted, or she had been smaller once, and the coat remembered. The collar was turned up against a cold that no longer existed inside the building. She hadn't noticed, or she had, and it made her feel safer, and I wasn't going to take that from her. Her hands were wrapped around the strap of a clear plastic folder, the kind you find in a dollar store. Inside it I could see papers, organized papers I noticed, receipts, printouts. She had prepared. She had come here with evidence because she believed still that evidence was what this place ran on. That broke something in me quietly, in the way things break quietly after you've had enough practice at it. She sat down at the respondent's table and placed the folder in front of her with both hands, very carefully. The way you place something down when you are afraid that if you let go of it completely, you will have nothing left to hold on to. I looked at her for a moment before she looked up at me. Her eyes were dry. That was the first thing I noticed. Not the redness around them, though that was there too. The particular red of someone who had been crying recently enough that the evidence was still in the skin. I noticed the dryness because it told me something. She had cried already. She had cried somewhere else. At home, in a parking lot, in a bathroom with the water running so nobody could hear. And she had made a decision before she walked through that door that she was not going to cry here. There is a kind of dignity in that I have always found almost unbearable to witness. The bailiff called the room to order. The court reporter's fingers settled onto her keys. I looked down at the file. Then I looked back up at Margaret Calloway. And I thought, whoever brought this woman into my courtroom had better have a very good explanation. The charge was read aloud at 9:03 in the morning. I listened to it the way I had learned to listen to charges, without expression, without reaction, with the particular stillness that 32 years on the bench teaches you, because your face is the first thing a frightened person looks at, and the last thing they need is to read something there before the facts are even on the table. The school district's attorney was a man named Garrett Pruitt, mid-40s, the kind of suit that costs more than some people in that room made in a month. He read from his papers with the confidence of someone who had never once considered that he might be on the wrong side of something. That confidence, I had learned, was its own kind of evidence. The charge was interference with administrative proceedings. A secondary notation cited repeated unauthorized presence on school grounds. A third line, almost casual in its cruelty, described the respondent as having engaged in behavior that created a hostile environment for school staff. I let the words finish hanging in the air. Then I looked at the folder in front of Margaret Calloway, the organized papers, the receipts in a clear plastic sleeve from a dollar store. The bailiff shifted his weight. The fluorescent light in the corner of the room flickered once and steadied. Pruitt finished speaking and folded his hands on the table. He had the posture of a man who expected applause, or at the very least the sound of a gavel agreeing with him. I did not pick up the gavel. I looked at the supporting documentation instead. It had been entered into the record, and I had read it before the session began. But I read it again now because I wanted to be certain I was understanding it correctly. Because sometimes language in a legal document is designed specifically to make something ordinary sound extraordinary, and something human sound criminal, and you have to read it more than once to find the person underneath the phrasing. Margaret Calloway had gone to Eastfield Middle School 4 times in 1 week. The first visit, She arrived at the main office and asked to speak with the principal about a notification she had received regarding her son's lunch account balance. She was told Principal Holt was unavailable. She left her phone number and asked for a callback. No callback came. The second visit, she returned 2 days later and was seen by an administrative assistant who told her the matter was out of the assistant's hands and had been escalated to a disciplinary proceeding. Maggie asked what that meant. The assistant said she wasn't authorized to explain. Maggie asked to see the disciplinary notice in writing. She was told it would be mailed. Nothing was mailed. The third visit, she asked again for Principal Holt. She was told he was in a meeting. She sat in the reception area and waited for 45 minutes. Holt passed through the lobby, looked at her, and continued walking. A security guard was called. She was asked to leave. She left. The fourth visit, she came with $12 in cash and 50 cents in quarters. She asked the front desk clerk if she could pay Tyler's balance directly, in person, immediately, so that whatever process had been started could be stopped. The clerk looked at the money. Then the clerk picked up the phone and called someone. 2 minutes later, Maggie Calloway was escorted from the building by the same security guard as before, and informed that a formal complaint had been filed against her for disruptive conduct. That was the hostile environment. A woman with $12.50 in her hand, asking someone to take it. I set the papers down. The second hand on the clock moved. Somewhere in the building a door opened and closed. Pruitt was looking at me with the expression of a man waiting for a formality to conclude. He had the injunction already prepared, I was certain of it. A restraining order keeping Margaret Calloway off school property. Something clean and official that would turn her desperation into a violation. I thought about the word hostile. I had looked it up once, years ago, not because I didn't know its definition, but because I wanted to read it plainly, stripped of the way lawyers use it. Hostile, showing or feeling opposition or dislike. Unfriendly, opposed. I looked at the clear plastic folder. I looked at the organized papers. I looked at the woman who had come to a courthouse, a place that frightens most people badly enough that they avoid it their entire lives, because she had run out of every other door to knock on, and this was the last one. I thought about what opposition looked like from where I was sitting. And then I thought about Raymond Holt walking through that lobby and continuing on without stopping, and a security guard being called, and a formal complaint being filed, and a disciplinary notation being placed in the record of a 14-year-old boy who washed cars on weekends and had written a scholarship essay 4 times because he wanted it to be right. The room was very quiet. I folded my hands on the bench and I looked at Margaret Calloway for a long moment. Her eyes met mine and she didn't look away. She was done looking away. I said, "Mrs. Calloway." Her voice came out smaller than she intended it to. "Yes, Your Honor. I've read the documentation on both sides of this matter," I said. "I have some questions for Mr. Pruitt's client, but I'm going to start with you." Pruitt's pen stopped moving. "I want you to set aside the legal language," I said. "Set aside the charges. Set aside what anyone has told you about how to present yourself in this room. I want you to just tell me." I paused. The clock ticked. "Why did you keep going back?" She looked at me like no one had asked her that before. Not the question itself. I imagine people had asked her versions of it. Her sister, maybe. A co-worker on the night shift. Someone who meant well and wanted her to stop, to let it go, to accept the particular kind of defeat that gets dressed up as moving on. But no one had asked it the way I asked it, without impatience, without the quiet suggestion already built into the phrasing that the answer was going to be inconvenient. She looked at me and I watched something shift behind her eyes. The held posture, the careful dryness, the decision she had made in some parking lot or bathroom to not come apart in a room full of strangers. It held for about 4 seconds. Then it didn't. She didn't make a sound at first. That's the thing people don't understand about real crying. The kind that has been waiting a long time to happen. It doesn't arrive with noise. It arrives with the face changing, with something that was being held in the jaw and the throat and the space just behind the eyes simply giving up the effort. The sound came after, soft, exhausted, the sound of someone who had been carrying something very heavy for a very long time and had just been told, for the first time, that they were allowed to put it down. She said, "He has 3 days." I waited. "Tyler, my son." She pressed the back of her hand against her mouth for a moment. "The scholarship application. The deadline is in 3 days, and they blocked it. They put something in his file and blocked it. And I went there every day because I didn't know what else to do. I don't have a lawyer. I work nights. I work every night. And I came home every morning and I called the number they gave me. And no one picked up and no one called back. And I just kept thinking, if I could just get someone to look at me, if I could just get one person to look me in the eye and let me hand them $12.50, then maybe." She stopped, took a breath that shook on the way in. "He wrote that essay 4 times, she said. 4 times. He showed me every version. He asked me if it was good." She looked down at the folder. "I don't know a lot about engineering. I don't know if it was the right kind of good. But I know my son. And I know when something matters to him the way nothing else has ever mattered. And Her voice dropped to something barely above a whisper. "I just needed someone to take the $12. The room was absolutely still. I did not look at Pruitt. I did not look at the bailiff or the court reporter or the handful of people sitting in the gallery that morning who had come for other cases and stayed for this one without quite knowing why. I looked at the folder on the table in front of her, the receipts, the printouts, the evidence she had organized because she believed this place ran on evidence and she was going to come prepared. Then I looked at Raymond Holt. He was seated behind Pruitt, slightly to the left in the gray suit and the wine-colored tie. And I will tell you something about his face in that moment. It had not changed. That was what told me everything I needed to know about him. Not the action he had taken, not the formal complaint, not the injunction Pruitt had prepared. His face, while that woman described her son writing an essay 4 times and coming to his building every day with $12 in her hand, had not moved. There is a specific kind of cruelty that doesn't know it's cruel. It wraps itself in procedure, in policy, in the clean language of institutional correctness. It looks at a human being and sees a variable in a system, and when the variable behaves in a way the system didn't account for, it reaches for a form. I had been patient. I was done being patient. I said, "Mr. Holt." He straightened slightly. "Your Honor, you were present on the 3rd visit Mrs. Calloway made to your school." A pause. "I was passing through You saw her." Another pause, shorter. "Yes. You recognized her." "I was aware of the situation, yes." "And you kept walking." It wasn't a question. He seemed to understand that because he didn't answer it. "You kept walking," I said again, more quietly now, which in my experience is far more frightening than raising your voice. "And then you had a security guard remove a woman who was sitting quietly in a chair, and you filed a formal complaint against her for, what was the language? Creating a hostile environment. The school has protocols for..." "Mr. Holt," I folded my hands. "I'm going to ask you to stop talking now, because what I have to say is going to go on the record, and I want it to go on the record clearly, without interruption." He stopped. "In 32 years on this bench, I have seen genuine hostility. I have seen people who came into institutions with the intention of causing harm. I know what that looks like." I looked at the folder again. "That is not what that folder is. That folder is what a person looks like when they have been failed by every system that was supposed to help them, and they still believed that if they just showed up one more time, with the right papers, someone would do the right thing." I picked up my pen. "Here is my ruling. The court reporter's fingers moved. The charges against Margaret Calloway are dismissed. All of them. Entirely. There was no hostile conduct. There was no interference. There was a mother who knocked on a door that should have been opened the first time. I turned to the next page of my notes. Regarding Tyler Calloway's scholarship application, this court is issuing an immediate order requiring Eastfield Middle School to lift all administrative blocks on said application within 24 hours, and to formally request, in writing, a deadline extension from the scholarship committee, citing administrative error on the part of the institution. Not on the part of the student, not on the part of the family, on the part of the institution. Pruitt had gone very still. The disciplinary notation in Tyler Calloway's file, the one categorizing him as financially irresponsible, a classification that, I will note for the record, does not exist in any educational regulation I have been able to locate, is to be expunged completely, as though it was never written, because it should never have been written. I looked at Holt one final time. And you, Mr. Holt, will personally pay the $12.50 balance on Tyler Calloway's lunch account. Not the school district, not the administrative budget. You, by the end of business today, you will walk to that school, or you will call, and you will give someone $12.50, and you will understand, I hope you will understand, that this is not a punishment. This is a lesson. The least expensive lesson you will ever receive about what it costs to look through a person. I picked up the gavel. He was looking at me now with something different in his face. Not contrition, not quite. But something had cracked somewhere underneath the gray suit, and whatever had been holding the certainty in place was not holding quite as well as it had been an hour ago. The gavel came down. Thud. Margaret Calloway put both hands over her face. I have thought about that morning many times since. Not every case stays with you. After 3 decades in this work, you learn, you have to learn, a certain necessary distance. You cannot carry every file home with you. You cannot lie awake replaying every face that sat across that bench, every voice that broke in the middle of a sentence, every pair of hands gripping a folder, or a hat brim, or the edge of a table, as though the furniture were the only solid thing left in the world. If you try to carry all of it, it will take you down. I have watched good judges break under the weight of cases they refuse to let go of. There is no honor in that. But some cases don't ask your permission. Some cases simply stay. I gave Raymond Holt 48 hours to comply with the order before I would refer the matter to the district superintendent. He complied in 6. I don't know if that was conscience or self-preservation, and I have stopped trying to determine which. The $12.50 were paid. The block on Tyler's application was lifted. The notation was removed from his file. The scholarship committee granted the extension. I know this because my clerk told me, 3 days after the ruling, that a woman had called the courthouse and asked to leave a message for the judge. My clerk told her that judges don't generally receive messages from parties in closed cases. The woman said she understood, and that she just wanted someone in the building to know that her son had submitted his application on time. My clerk wrote it down and left it on my desk anyway. I kept that note in the top drawer of my desk for the rest of that year. I heard nothing more for 14 months. Then, on a Tuesday afternoon in January, a letter arrived at the courthouse addressed to my attention. The envelope was plain. The return address was a street I didn't recognize in the eastern part of the city, the part of the city where the houses are small and close together, and the corner stores stay open late because people work shifts that don't end at reasonable hours. Inside was a photograph. A young man in a gray collared shirt with an embroidered logo on the chest, standing in front of what looked like a workshop. Fluorescent lighting, metal shelving, the organized clutter of a place where things get built and fixed and understood. He was smiling the way people smile when a camera catches them mid-laugh, when they don't know quite how happy they look. He was 16, maybe 17 by then. He had his mother's eyes. On the back of the photograph, in careful handwriting that pressed slightly too hard into the paper, the handwriting of someone who was concentrating, who wanted to get it right, were these words. First day of my engineering internship. Mom said I should send you this. She said you'd want to know. I looked you up. I read about some of your other cases. I want to do work that matters too. Thank you for seeing us. Tyler Calloway. I sat with that photograph for a long time. I thought about the morning I first saw his mother walk into that courtroom. The green coat, the folder, the dry eyes that had already done their crying somewhere private. I thought about the way she said he wrote it 4 times. Not as an argument, not as evidence, just as a fact she needed someone to know. The way people tell you the most important things not because they expect it to change anything, but because the truth of it is too large to keep entirely inside. I thought about a boy I used to know, a long time ago, in a city not so different from this one. A boy with a father who came home from the factory smelling of metal, and a mother who pressed other people's shirts. A boy who wanted to stand in a room like this one someday and be the thing between the coldness of the system and the humanness of the person standing in front of it. I thought about a teacher who once told that boy in front of his classmates that he owed $3.80 and that he could not compete until he paid it. I thought about how close it all is, always. How thin the margin between the life that happens and the life that almost did. I pinned the photograph to the inside of my office door, where I would see it every morning when I came in and every evening when I left. My clerk asked me once who the young man was. I told her he was a reminder. She nodded as though that made complete sense, which, in a courthouse, it does. Raymond Holt retired the following year. I don't know if the ruling had anything to do with it. The district's review of Eastfield Middle School's disciplinary practices resulted in a revised policy on student financial matters, one that explicitly prohibits administrative action against students for billing errors or processing delays in subsidized lunch programs. It is a small policy. It is 2 paragraphs long. It will never make the news. But somewhere in this city right now there is a child eating lunch whose scholarship application is intact, whose future has not been trimmed to fit a balance sheet, whose mother will not have to walk into a building 4 times with $12 in her hand, hoping that this time someone will look at her. That policy is 2 paragraphs long and it will never make the news. It is also the most important thing Raymond Holt ever did, even though he didn't do it willingly, and even though he will never understand that. I have thought about what justice looks like over the years. Early in my career, I thought it looked like a verdict. Then I thought it looked like a sentence. Then I thought it looked like a ruling that nobody could appeal. Now I think it looks like a 17-year-old boy in a gray-collared shirt standing in front of a workshop, caught mid-laugh, not knowing how happy he looks. Now I think it looks like a mother who stopped crying in parking lots because she ran out of reason to. Now I think it looks like 2 paragraphs in a school policy that no one will ever read unless they need it. And then it will be the most important thing they have ever read. I have been in this courthouse for 32 years. I have seen the law fail people it should have protected. I have seen it reach people it had no business reaching. I have seen it wielded like a weapon and ignored like an inconvenience, and occasionally, used exactly the way it was always meant to be used, as a door, as the last door, the one that's still open when every other one has been closed in your face. Margaret Calloway walked through that door with $12.50 and a folder full of organized evidence and the specific dignity of a person who refuses to stop trying. Tyler Calloway sent me a photograph from the first day of his engineering internship. If this story stayed with you, I want you to pause for just a moment and ask yourself something honest. Have you ever stood in front of a closed door? Not a door made of wood, but one made of policy, of procedure, of someone who had the power to help you and simply chose not to, and had to decide whether to knock one more time or walk away. Have you ever watched a system treat a person like a number and said nothing, because you didn't know if saying something would matter. And have you ever underestimated someone? A student, a stranger, a person in a worn-out coat, and later understood, too late or just in time, exactly what that cost them. The law is supposed to be the last door that stays open. Margaret Calloway walked through it with $12.50 and the quiet, unbreakable dignity of a mother who refused to stop trying. Tyler Calloway became an engineer. Tell us in the comments what this story brought up for you. We read every single one. And if you believe in stories about compassion, dignity, and the power of refusing to give up, you already know what to do.